Good afternoon, everyone, and welcome to today's Thriving After 60 presentation, Estate Planning, with our host, Elsa Smith. As always, if you have the need to adjust the volume, excuse me, if you have the need to adjust your volume on your device, you have the ability to do so, as well as the picture, depending upon where you are in relation to your device. So, without further ado, here is Elsa Smith. Elsa?
Good afternoon, everyone, and thank you for being here today. My name is Elsa W. Smith, and I am honored to speak with you about a topic that affects every family, estate planning. Today's presentation is called Dignity Preserved, Protection Ensured, a practical guide to estate planning. My goal is to make this topic feel less intimidating and more approachable so that you leave informed, empowered, and encouraged to take action. I'd like to begin by thanking Kaiser Permanente for the opportunity to serve and educate the community. Kaiser Permanente understands that wellness involves more than physical health. Health planning and legal planning truly work hand in hand. Estate planning helps ensure that your wishes are honored and your loved ones are protected during life's most difficult moments. Our shared goal today is to make estate planning clear, approachable, achievable for everyone, and ultimately to help create peace of mind. Estate planning is not just about documents. It's about preserving dignity, reducing stress for loved ones, and making sure that your voice is heard. Now, a little about me. I'm the founder and managing member of the law offices of Elsa W. Smith here in Annapolis, Maryland. I've practiced law for more than 25 years with a focus now on estate planning, probate, and business formation. Our firm's mission is empowering women through estate planning. Over the years, I've seen firsthand how proper planning can preserve dignity and reduce family stress. Please remember that today's presentation is for general education purposes only and is not legal advice. Every family situation is unique, so individualized legal guidance is important. So by the end of today's presentation, my hope is that you will understand the basics of estate planning, learn practical next steps, and feel more confident in taking action. You do not need to become an expert today. Even small steps can make a meaningful difference. All right, so we're going to get started now. Hope you're taking notes. Here we go. So what exactly is estate planning? Estate planning is creating legal instructions for what happens if you become ill, incapacitated, or pass away. It is not just for the wealthy. Estate planning is for everyone because everyone deserves a say in who can help them, who can access information, and how their affairs are handled. At its core, estate planning is about protecting yourself and the people you love. I once met a woman who told me, I thought estate planning was only for wealthy people. She owned a modest home, had adult children, and considered herself pretty organized. But after a health scare, she realized something important. Estate planning wasn't about wealth. It's about making sure someone she trusted could step in if needed. And once she eventually completed her documents, she told me that she finally felt at peace because her family wouldn't have to guess what she wanted. Trying to advance the next slide. There we go. All right. Now let's start with a quick poll. Have you created an estate plan? And folks, there are no wrong answers here. This is simply a chance to see where everyone is starting from today. So let's go ahead and launch that poll, please. There we go. And we'll give you about 10 seconds to answer that because we want to keep this train running.
So there's one more person to answer.
Okay. Great. It looks like everybody has answered. Okay. We're going to take it off screen. It looks like just, a little over half of you do not have an estate plan. About half of you do, more than half do not. And that's okay. That's in line actually with what the numbers tell us. There's a number of years ago, a large, well-known organization representing seniors published an article stating that more than, I believe it was like 65 or 70% of people don't have a will or any estate planning. So that's in line with what we're seeing nationally. I'm going to move on to there we go. Now, there are many myths surrounding estate planning. Some people believe, hey, I don't need a will. My family will know what to do, or everything automatically goes to my spouse. And the last one, I'm too old to start now. In reality, estate planning is valuable at every stage of life. And waiting can sometimes create unnecessary stress and confusion for loved ones. Here's a story. I once spoke with a family after the passing of a parent who had repeatedly said, my children will know what I want. The problem was that each child remembered different conversations differently. One believed that the house should be sold. Another believed mom wanted one child to keep it. So that disagreement created tension during an already emotional time. Often, estate planning is less about legal paperwork and more about reducing uncertainty. Let's do another quick poll. Which myth did you believe before today? And you may be surprised how common these misconceptions are. So we're going to launch that poll, second poll, and I'm anxious to see what folks respond to. Good. Let's get those answers going. Yep. Okay, just a few more, almost everybody. Just a few more of you. Click one of those. If you have ever believed one of these myths, it's okay. There are no wrong answers. Trust me. And it looks like we're waiting for just less than a handful of folks. There we go. Give it about 3 or 4 more seconds. I want to really get everybody engaged here. 1, 2, 3. Okay. So we're going to go ahead and end the poll. So the results are pretty across the board. Some folks said I don't need a will. Yeah, most, and this is interesting, I think that they don't need a will, and another set believed everything automatically goes to my spouse. But it's nice to see that, not nice, but it's interesting to see that the responses are pretty scattered across the different myths, and that's okay. That is absolutely okay. We are going to keep moving, and there we go. Now, I'd like to describe these documents as the core 4 estate planning documents. These documents work together to create a foundation for protection and decision making. So they include a will, a power of attorney, an advance directive, and a HIPAA authorization. And each one serves a different but important purpose. Now, this slide gives a simple overview of the role each document plays. So your will controls inheritance after death. A power of attorney helps protect you while you are living, by allowing someone to handle financial and legal matters if needed. An advance directive communicates your healthcare wishes. And then finally, a HIPAA authorization allows loved ones or trusted individuals to access medical information when necessary. Okay, another quick poll. Do you currently have any of these estate planning documents in place? Some people have a few documents, but not all, and that's very common. Again, no wrong answers. I just want to see where we are. And let's go ahead and launch that poll, please. It should come up in just a second, everybody. While we're waiting for that poll to launch, I want you to think about it because there are some folks that may have documents that are pretty old and maybe you forgot about them because they're so old. So let's go ahead and let's see. There we go. All right. Okay, everybody. Yes or no? Good. Okay. The yeses are leading. Yay. I like to see that. Just waiting on a couple more people to answer and give it a few more seconds and then we will close the poll. But I am happy to see that most people are answering yes. Looks like one more person. And okay. All right. I'll give it one more second and then we'll close. All right. Okay. So looks like definitely more of you than not, just a little over half, which is fine. I'm glad. I'm glad that at least you have some of these documents. So your minds are in the right space. So very happy about that. Oops. Here we go. Okay, let's begin with the will. Now, a will allows you to decide who inherits your property and who will handle your estate administration. All right, without a will, for those of you who are residents of the state of Maryland creates a plan for you through intestacy laws. And the word intestacy just means if you died without a will, right? So as I always say, if you don't have a plan, the state will have one for you. So that plan may or may not reflect your wishes. A will can also help minimize confusion and conflict among family members. And remember, estate plans should evolve as your life changes. So I'll share another story. A gentleman remarried later in life, and he assumed everything would automatically pass to his wife or spouse. But he also had adult children from a prior relationship. Now, after his passing, the family discovered that Maryland law did not distribute assets exactly the way he expected. So a clear will could have helped reduce confusion and conflict. Next, we move on to the power of attorney. A power of attorney is one of the most important incapacity planning documents. It allows a trusted person to handle financial or legal matters on your behalf while you are living. And importantly, it can continue even if you become incapacitated. Imagine, say, if you have a daughter, your daughter needs to access your bank account to pay your mortgage while you're hospitalized. Without proper legal authority, that whole process can become really difficult. A power of attorney can help avoid unnecessary court involvement and reduce stress for loved ones. Now let's talk about the advance directive. An advance directive focuses on healthcare decisions. It allows you to name a healthcare agent, communicate treatment preferences, and provide guidance during difficult medical situations. One of the greatest gifts this document can provide is clarity. It relieves loved ones from having to guess what you would want during emotionally stressful situations. Here's another story. I once heard someone say, the hardest part wasn't making the medical decision. The hardest part was not knowing whether it was what my mother truly wanted. Advanced directives can provide clarity during emotional moments and help relieve loved ones from carrying the burden of guessing. A HIPAA authorization. It allows designated individuals to access your medical information. And I should also say that it's a good idea to have both the advanced directive that we just reviewed, as well as a standalone HIPAA authorization. It's just a good idea. Without proper authorization, loved ones may sometimes face barriers when trying to communicate with healthcare providers. Even spouses may encounter difficulties depending on the situation and the provider's policies. So this document helps to keep communication open and supports informed decision-making. So here's an example. A family member once described the frustration of calling a hospital repeatedly and struggling to get updates because the proper authorization wasn't in place. So during medical emergencies, families are already stressed. So proper documents can help improve communication and coordination, right? So this is another document that really empowers you to give information to those individuals that you want to have information, right? So not everybody should be entitled to know what's going on, but certainly the core few, the trusted few individuals who really love you, care about you, and are involved in making decisions on your behalf, they should certainly be listed on this HIPAA authorization. So now let's briefly talk about a revocable living trust. Now, a trust, just shorthand, a trust can help manage assets during your lifetime and may help avoid probate for properly titled assets. However, a trust does not replace your other estate planning documents. It works alongside them. Whether a trust is appropriate really depends on your goals, your assets, and your specific family circumstances. So just to share with you an application of this, one family's largest asset was their home. After the owner passed away, the property became tied up in probate for an extended period of time before it could be sold. And just a note here, probate is the court administration of your estate, right? The court supervision of it. So the family in this case, the family wasn't expecting all these delays and administrative processes. For some families, a properly funded trust may help simplify the transfer of certain assets. One important concept is trust funding. A trust only works properly if assets are connected to it. Some assets may be transferred into the trust directly, such as real estate, valuable personal property, or certain investment accounts. Other assets may name the trust as a beneficiary, and some assets often pass directly to individuals through beneficiary designations. Now, you'll notice I mentioned that some retirement accounts may name a trust as a beneficiary. So that decision depends on several factors, including tax considerations, the type of retirement account, and the particular family's goals. For some families, naming individuals directly makes sense. In other situations, naming a trust may help provide structure or protection. This is one reason individualized legal advice is so important. I'll share a story with you. This is a great teaching story. Sometimes people create a trust, and think of a trust as like a large bucket, right? They create it, but they never transfer assets into it. And sometimes I explain it to folks this way. Creating a trust is a little like buying a safe, but never putting anything inside, right? So the trust exists, but the assets were never properly connected to it. Let's do one final poll. Would you consider including a living trust as part of your estate plan? This will help us understand how people are thinking about planning beyond the core 4 documents that we referred to. So the poll has launched. All right, people are responding. You're engaged. I'm loving this. This is great. A lot of people considering trusts.
We should have said this earlier, but there's a little icon down at the bottom of your screen that says polls/quizzes. That's where you'll be able to respond to the question. Some of you have responded to the questions on the chat line. I just realized that a short time ago. So we should have given you better directions on how to use the poll. But just if anybody has any difficulties finding the polls/quizzes, let me know and I'll help you find it. As of this time, 13 of the 16 attendees have responded to this question.
Okay, thank you so much. We'll give it a couple more seconds to let everybody participate. And I am loving these answers. Looks like the vast majority of you are considering a trust. And again, a trust may not be for everybody, but at least think about it. And okay, I guess we're going to
end the poll. Okay.
Yes, we're going to end the poll.
And share the results.
Yep. Look at that. Most of you are at least thinking about it, which is great. Great. So we're going to stop sharing. Looks like. Okay. Let's see. There we go. So to summarize, your estate planning toolkit, if you will, may include a will, power of attorney, advance directive, HIPAA authorization, and in some cases, a living trust. Estate planning is not one size fits all. The right plan depends on your unique family goals and circumstances. Estate planning can feel overwhelming, but remember, please remember, you do not have to do everything at once. So my suggestion is to start by gathering existing documents, if you have them, right? And then identify the gaps, right? And then speak with a qualified estate planning attorney. Even one small step today moves your plan forward. And as I alluded to earlier, some of you may have documents that are 10, 20, 25 years old. Laws change in your particular state, your jurisdiction, every 5 years, 6, 7, 8 years. So it really is a good idea to update, or what I call refresh, your estate plan. Documents may be updated. You may have options that are now authorized that weren't authorized when you originally completed that particular part of your estate plan. So many people think that estate planning means, okay, I've got to complete everything perfectly all at once. But the most important step is simply getting started. You know, I've seen clients feel immediate relief after finally scheduling the appointment they've had postponed for years. And I'll tell you, many folks call the office, and one of the things they tell our intake specialists is that they've been putting it off for years. It's something they knew they had to do, but they just never got around to it. And the truth is, we always push estate planning off, put it on the back burner. And sadly, something tragic happens either to our immediate family or someone we know, and then it brings estate planning back to top of mind. But we don't want to do that. And the people on this call, I have a feeling, are the proactive ones, right? Estate planning is important. We don't want to wait until there is an emergency or a crisis, because that's not the best way to plan. The time to plan is when your mind is clear, you're not stressed, there's no sense of urgency, you can think clearly, because that's going to help you in determining who are the people that you want involved in these key documents that we've talked about during this presentation. One thing that I tell clients is that, at least with our office, we do not make decisions out of guilt, pressure, or obligation. We want these trusted individuals involved in your plan to be the right fit, to have the right skill set, to be able to respond if and when the need arises. So let me give you an example. A power of attorney. We talked about this earlier. What would make an ideal person to be your power of attorney agent? Certainly a trustworthy person. That should go without saying. Somebody responsible. And you probably do not want a person who doesn't manage money very well or has a lot of financial problems going on. The fact is that having a power of attorney, as I'm describing in this example, is too powerful of a document, and the temptation can be very great for the type of person that I just described. It's just too tempting for that person to say, access your account, your bank account, and take a little, what I call the nibbles. They start off with the nibbles, and they've got the power of attorney. It's been lawfully executed, and they go to your bank, they show it to the bank, sees that it's legit, and allows this person to withdraw money. If this person doesn't have their priorities straight, or more specifically, they do not have your best interests at heart, they start withdrawing little by little. And sometimes they tell themselves, I'll take a little now and then I'll put it back. this person won't mind. But just that taking is a breach, a violation of that duty that they have to protect your interests. And it's not right. And that's not the person that you want. And I know some people have a really hard time with it because sometimes that person is a family member. And that creates this whole other kind of drama. But as your representative, if they're coming to me for legal advice and guidance on estate planning, I tell them, I say, listen, you can blame me. Tell the person, listen, I didn't think that they were a good fit, because my job is to protect you and to make sure that you're making informed, educated decisions that empower you, right? So many people create documents and never look at them again. So this slide is, when should you update your estate plan? Estate plan should be reviewed periodically, especially after major life changes, such as marriage, divorce, loss of a loved one, birth of children or grandchildren, health changes, financial changes, or moving to another state. A well-drafted plan should evolve with your life. Sometimes people create estate planning documents during one season of life, but years later, their circumstances look very different. Children become adults, grandchildren are born, relationships evolve, people move to another state or experience health changes. Estate planning should grow and change as life changes. So as we begin to close, here are 3 things I hope that you remember. Planning is an act of love. Everyone needs a plan. And small steps today can create peace tomorrow. Estate planning is not about fear. It's about preparation, dignity, and care for the people you love. One of the most meaningful comments I heard from a client was, Attorney Smith, I thought estate planning was about death, but now I realize it's really about protecting the people I love while I'm living and after I'm gone. They got it. That's truly what this work is about. I want to thank you so much for your attention and participation today. It has truly been an honor to spend this time with you. I also want to again thank Kaiser Permanente for the opportunity to serve the community. If you'd like to stay connected or learn more, please feel free to scan the QR code on your screen right now. You can scan it with the camera on your phone. Now, if you are in Maryland or the District of Columbia, you can also call us at 410-995-7719. Again, 410-995-7719. And now I'd be happy to answer any questions you may have with our remaining time here. And Mr. Moderator, do we have any questions in the chat?
Yes, Elsa, we do have a number of questions. Let's start with William. William has 2 questions. The first question is, are there any online resources you recommend for how a single person with no children can approach developing an estate plan and naming appropriate agents for the various estate planning documents?
Great question. There are. And as a matter of fact, I'll just share that on my website, elsawsmithlaw.com, there are free resources available to you to address that particular issue. I also have a YouTube channel at Elsa W. Smith Law with hundreds, literally hundreds of videos that, and you just search for the topic that you're looking for, and you're bound to run into it, because there are hundreds, literally hundreds of videos free of charge and available to the public to that will answer those questions. But yes, single individuals absolutely need estate plans. That's one of the things that I encounter in my practice. Folks will contact the office and say, "I think I need something, but I don't have kids, or I don't have other family members." Yes, you do. You need a plan, because you are worth protecting, right? So great question.
And we will put those email addresses in the chat. Elsa, just remind me that we want to have you put those in there. But let me give you William's second question. Is
Okay.
naming a bank or legal firm person to act as agents versus naming a family member or friend advisable? Question.
Good question. You wouldn't necessarily name the bank itself. You can name someone who sometimes people name an attorney who chooses to be a fiduciary, but those are very limited situations. You don't have to name a family member. Let me start there. Again, hopefully what everybody got from this presentation is that whoever you name needs to be a trusted individual. So I've had clients who said, "Attorney Smith, honestly, there's not many people in my family that I trust to handle X. However, I do have this great best friend from college who has been with me through thick and thin, and I literally trust that person with my life." And I go, "There you go. That's the person that you need to appoint for that position." So I want everybody on the webinar to just expand the scope of the folks that you're considering for these crucial positions. Look outside your family if there's no one in your family that has the right skill set. I mentioned that before during my example of when I was discussing the power of attorney. You want to choose, and you know your family better than the attorney that you're hopefully going to connect with after this webinar. You know your family. Let's be honest. And you know the skill sets that every family member has, what their strengths and weaknesses are, right? And it's up to you to make the right choice, because this is about empowering you. It's your plan, not your family's plan. It's yours. And the people that you appoint have got to be able to step up to the mark if and when the situation calls for it. So great question.
Thank you. Barbara asks, does the estate attorney have to be in the same county or city where you live?
Another excellent question. Not at all. As long as the estate planning attorney is licensed in the state where you're transacting, where you live, that is fine. Represent individuals. I'm licensed in the state of Maryland and the District of Columbia, so I can represent anyone living anywhere in the state of Maryland, any county, any city. So great question.
Thank you, Elsa. Joyce has three questions. The first one is, does the same person need to be on your advance directive and HIPAA authorization, or can it be different people?
Okay, let me take that question. It should be, just for consistency, because in the advance directive, there is a small section that it's kind of like a mini HIPAA authorization. It's a small paragraph that's overlaps with the standalone HIPAA authorization. And what you want is to make sure there's alignment there. So anyone that you mention in the HIPAA. So for example, you have your primary agent and then a backup, a secondary, right? Johnny and Jane. So you want to make sure that Johnny and Jane are also listed on the HIPAA authorization, so there's no hiccups if and when the need arises.
Do you have to file your will with the clerk at the courthouse?
Boy, you all have gotten great questions. If your estate plan is a wills-based plan, right? So we're not even talking about trust. If it's just a will, it is not required, but I recommend to all of my clients, and it's a best practice, at least here in Maryland, to register your will. And each county has an office called the Register of Wills. That's literally what they do. They not only accept wills for safekeeping, but they are also the office that your loved ones will work with after you pass away and your estate needs to be administered. And here in Maryland, it's a very minimal cost, like $5 really. And they keep your original will for safekeeping. If you choose not to do that, my recommendation is that you keep the will and as well as all your other estate planning documents in a fireproof, waterproof container, a safe in your home. And also, here's the other thing, also let at least one trusted person know how to get to those documents. But that's another conversation. But going back to do you have to register your will? No, legally you don't, but it is highly recommended that you do, because the Register of Wills, as I said, they keep all of the original wills in a vault. And when a person passes away and a loved one comes in and lets them know that this person has passed away, but they registered this will, they have a huge database. So they'll go in and they'll search for your deceased loved one's name and you'll pull it right up and they'll know where to find it. So great question.
And here is Joyce's third question. Just verifying that the power of attorney is only active when you are alive and ends at death, and then the will kicks in.
Okay, I'm going to answer that in two parts. So yes, the power of attorney is only good while you're alive, right? Period. Full stop. There's also language in the power of attorney that allows you to revoke, end the power. So it typically will end when you die. But if you don't want the person you chose as an agent, you don't want them acting on your behalf anymore, assuming that you are able to communicate that to that agent, and the law just requires that you are able to communicate, hey, I don't want you acting as my agent anymore. Yeah, you can revoke it. But yes, if there's no other restrictions, then yes, the power of attorney ends automatically when you die. Now, as to the will kicking in automatically, no, it does not. A will needs to be presented to the Register of Wills in the county where the decedent resided. And it is only at that point that a matter is open, an estate is opened, that things start moving. So just because a person dies, the will does not automatically kick in. It needs to be presented to the local Register of Wills to start the process.
Thank you.
Excellent question.
Dolores asks, what is the difference between a power of attorney and a POD?
Okay. A power of attorney is the document that we referred to in this presentation. So it is a legal document that authorizes another person to act on your behalf, to make legal and financial decisions. And it's the shorthand for it is POA, right? So that's power of attorney. A POD, stands for payable on death, right? That a lot in financial accounts, right? So the banking institution or the financial institution will let you know that the account that you've opened up is a payable on death account. And what you want to make sure and do is name a beneficiary on that account if it's a payable on death account. Because what that does is that at your death, the whatever monies are in that account, the banks are instructed that payable on death beneficiary is to receive those funds. Doesn't need court intervention at all. It just is assuming that the person provides identification, proof of death, that sort of thing. Yes, that's a payable on death account, and that's the process of it. So that's the distinction between a power of attorney, a POA, and a payable on death designation, which is a POD.
Thank you, Elsa. Beverly wants to know, does the person listed on a power of attorney have to live in the same state?
Boy, I love this. I love this audience. I wish I could
Oh,
see
there are a
all of
lot more.
you.
There are a lot more questions, Elsa.
I know
Go,
we only have a few more
go,
minutes before we wrap
go.
up, but these are great. No, the person does not need to live in the state, but it is highly recommended. Here's why. Because you want someone that they either live in the same state or they can easily get to the state if you needed someone to act right away. So, and I know that people live in different places and they're transient, but can they get here by train, by airplane, by car? Is it an easy car drive? If they're like just over the border in another state, may not be an issue. But say if the power of attorney agent, you live in, and for those of you watching, we're in the United States, obviously. But if the power of attorney agent is in Italy, might be a challenge, right? Person's got to fly to the United States and all the logistics that go along with that. So just think very carefully and make sure that person can easily or relatively easily get to you if the need arose.
Beverly also wants to know, how do you get forms signed and notarized if you live in different states? She says specifically Maryland and Texas.
So if is the question if let's say if she's doing her estate planning, she would get the documents signed and properly notarized as needed in the state where she resides. I'm not sure.
But if the person who has power of attorney is in a different state, such as Texas, and Beverly lives in Maryland, how does that get done for
What
notarization?
Oh, okay. There are, at least in the power of attorney document in Maryland, there is a section at the end of it that's an affidavit, an agent certification, actually. The agent gets that notarized. In the example she just mentioned, if the person, say, is in Texas, they can get the certification done as long as it's by a proper notary and so forth, and attach it to the power of attorney that was signed in Maryland in order to, assuming that there are no other restrictions or conditions in the power of attorney, that's how that can be done. Now, the reality is that banking is done online and we're using technology. So if an institution would accept you scanning and sending the power of attorney document that you have, even if you're in another state, that may be what's acceptable to allow the Texas agent to begin acting on the Maryland individual's behalf.
Yeah.
But that's
So
going to
Beverly,
depend.
yeah, Beverly
So
has
that,
given us some additional information.
oh,
She's
okay.
working on her dad's situation. He lives
Mhm.
in Texas. He's 91 years old, and
Mhm.
Beverly lives in Maryland and will be the agent POA.
I Obviously I don't practice in Texas, but I would imagine that the example that I just described, that's how it would apply. And she would be able to act as agent, assuming that the Texas power of attorney was properly signed and hopefully supervised by an attorney to make sure that all the I's are dotted and T's are crossed. But again, like I mentioned, it depends on the institution and whether how easily they work with technology and so forth as to how easily she'd be able to act on his behalf. But typically nowadays, it should not be a problem. But again, everything I answer everything with it depends.
Beverly says thanks and thank you. This helps a lot.
Good,
Okay, then we have
good.
two questions that work for me. Michael and Purash both wanted to know if they will receive copies of this presentation and a recording of this presentation. And we do that routinely for anyone who registers for the class. And so later today or possibly tomorrow, you'll be receiving an email to the email address that you provided when you registered. And on that email, there will be a link. Press on the link, you'll be able to see this full recording. And if there's something that you think you heard, but you may have misunderstood, you'll be able to play it back so that you'll get the exact words that Elsa shared with us. And you'll also be able to review the information that you received on this presentation. And last call for questions. If anybody wanted to ask their question directly of Elsa via their microphone, just let me know in the chat that you want your microphone open, and I'll be happy to open up your microphone so that you can ask Elsa a question that you prefer to ask rather than put in the chat.
While
And
those are, oh, I'm
yeah,
sorry, go ahead. I'm sorry.
we appreciate all the hearts that are going up our screens.
Yes, I wanted to
Uh,
acknowledge
and
them.
I'm
Thanks
sure,
so
and
much.
I'm sure those are for Elsa. And so thank you very much for that. And going once, going twice.
And again, it's really been a pleasure spending time with everybody. I love this work. I'm passionate about it. And if this webinar just gave you that nudge that you needed, it just fills my heart with so much joy because it's about education, and education leads to empowerment. So thank you guys, everybody, for being here today.
Barbara says, thank you for a stress-free presentation.
Oh, good.
We do some classes with heavy exercises. They don't always say that they're stress-free. They kind of say that they're exhausted. Okay, so let's see. Linda says, what's the price range for a will?
That all depends, and we as a firm, we never give prices or quotes ahead of time because every person's situation is different. We, like I said, in our firm, we have an intake process, and it begins with a 15-minute complimentary assessment call to generally determine your needs and to see what documents you need. And then if it's suitable for you to schedule an appointment with me, a consultation with me, at that point, I'll do a deeper dive. And then at the end of that consultation, I'll give you the quotes, the financial investment needed for the documents that I would recommend.
Joyce asks, in a revocable trust, if you leave a house to children, will they get the house immediately?
The short answer is no, because even in a trust administration, there are other taxes that need to be paid. There's a period of time, and again, this depends on the state, but in Maryland, there is a period of time where creditors are allowed to, first of all, they're required to be notified that a person has passed away, and then they have a particular period of time during which they can stake a claim against the estate. So that has to happen. And then after that's done, after taxes or any applicable taxes are paid, then the transfer of the house can happen in accordance with the will, the trust.
And finally, Courage says thanks. Brenda says thank you. Shirley says thanks. And Catherine says thank you with a red heart next to it.
My pleasure. It's been an honor, everybody.
So we thank you for your support. We thank you for your support for Thriving After 60 programming. One more question from Catherine. What if you have added children to the house?
Okay. And what's the follow-up? I'm sensing that there's a follow. What if you've added children to the house, and what's the concern?
I'm not sure. Unless she's wanting
Well,
to know.
let me attempt to answer it thinking, okay, so that's something significant. If you have
It's in their name already.
Oh, okay. So what happens to the house? Again, when you, and this can be the topic of even another webinar, it's whether you should add children or other individuals as owners to the title of your property. You've made them owners at your death, and depending on how the deed is written, the property may automatically transfer to them by operation of law. And that transfer occurs outside of any kind of probate or court process.
Okay, great. Well, thank you all for joining this first presentation with all the questions. I think we're probably going to be doing this again. And so more thanks, bunches. And so thank you so much, Elsa. We all appreciated it. And until next time, Thank you for supporting Thriving After 60 programming, and we'll see you next time. Bye bye, everyone.
Take care.